Miscellaneous application, miscellaneous cause number 31 of 2025. Meaning that the civil courts have no control, and if there was no transfer, and therefore, what would be the basis of the magistrate who was actually so, my lord, we implore you to agree with us in that regard. My lord, on the day of committal, on the 29th of May 2025, it was submitted by defense, all the applicants, my lord. Record on 29th of May 2025, representing the applicants before Nakawa. They only, my lord, out of protest, ran out of court. They went out of court, my lord, and court had nothing to do but to proceed with the committal. And that was the second time, my lord. It also happened on the 26th of May 2025. My lord, not actually repeat, arguing that this bail, the mandatory bail, that applicants had actually clocked mandatory bail, and therefore this court has no option but to simply release the applicants on bail. There are so many authorities, my lord. My lord, by the time of committal, that is on 29th of May 2025, had clocked mandatory bail. Twenty-three 6C of the Constitution. And it has also been misinterpreted. My lord, with all due respect to the authorities that have been provided, there has been a misinterpretation of Article 3C, reached in the petitions where the applicants had not been committed to High Court. And those are only cases, my lord, where this court is bound. The applicants in those cases had not been committed to High Court. The other cases, my lord, which have been cited, my lord, from the High Court, my lord, with all due respect, there was a misinterpretation and misapplication of Article 23 6C. And since the Supreme Court cases cited by the applicants, since there is a difference between the Supreme Court authorities provided by the applicants before you, my lord, and the High Court cases, my Lord, which we shall not repeat, we agree, my Lord, with my senior colleague, Lord Mayor, Elias Lukwago, that you can take a different direction. Because you're not bound by the judgments of High Court. Actually, this, it would be also, my Lord, a misinterpretation of Article 126(2)(e). Because then, if the applicant or the accused person has been committed to High Court, I invite you, my Lord, to interpret Article, to apply Article 23(6)(c) in a proper way. Because the applicants, that is on assumption, my Lord, that you disagree with the respondent and agree with the applicants that indeed by the time of committal they had clocked mandatory. That is if, of course, that is not our submission. But if you are inclined to believe that by the time of committal the applicants had clocked mandatory, we submit, my Lord, that you interpret Article 23(6)(c) objectively. But these criminal matters have different stakeholders. They have victims, they have the public, and therefore it is a submission that what would be at stake at that material point, like now, is to have the matter heard, not bail. I guess, my Lord, had my senior colleague for the applicants question the status of the respondent on the hearing of this matter. Office of the DPP does not consist cases. It is the judiciary. So you're innocent, you're castigating the office of the Director of Public, which is actually doing a perfect job. And my Lord, once you agree with us that the applicants, my Lord, that the charges before the General Court Martial did not apply in the current charges that were pressed, and the applicants actually facing before in criminal case, in court case number 008 of 2025, then this application collapses. Because as of today, my Lord, the applicants have been, by the time we filed our response, they had been in custody for 162 days. It will be unconstitutional and a bad precedent, my Lord, to hold the office of the DPP liable for matters that appeared before the General Court Martial. Yet the Constitution actually bars office of the DPP from taking over and discontinuing such cases. Application collapses on that particular point.